The Me Too movement. Even as dramatic headlines have captured attention, many women report that they've seen zero changes in their workplaces. So what can you do as an employer to protect your employees, to improve the quality of your workplace experience, and to protect your company and your supervisors and managers from liability? Well, this is stuff I've been telling employers for a long time, and it's very important in this day and age, in this time, that we focus on this and that we do our very best to comply with the requirements and go beyond. Zero tolerance is really the catchphrase that we all need to have in mind. Make sure you have an updated sexual harassment policy and complaint procedure in place. Make sure it's current. Make sure you have at least one male and one female designated and trained to receive complaints of sexual harassment. Require supervisors and managers to attend workplace training on this topic. Make sure they can spot the issues. Make sure that they're not putting their heads in the sand when they see a potential issue, but rather that they're going out, talking to their folks, and pursuing potential problems that they perceive. Make sure they know how to handle it when somebody comes to them with a complaint. Require employees to attend training. Make sure your employees know what they're entitled to in your workplace, that you have a zero tolerance policy, and that they can go to a manager or supervisor or one of the designated individuals to bring a complaint or concern. What is unlawful harassment? This is a primer in basic harassment law. Unlawful harassment occurs when a worker is subjected to a hostile work environment because of their protected status. That's the general broad definition of unlawful harassment under the anti-discrimination laws. And what are the protected characteristics, the protected categories? Here's a list. Age, race, color, sex, which includes pregnancy and caregiver status, national origin, sexual orientation, gender identity, military service, veteran status, disability, genetic information. Harassment, discrimination based on any of these characteristics is unlawful under state and federal law. What constitutes harassment? It can be verbal, it can be visual, an image, a cartoon, it can be physical. Once I was at a workplace of a client investigating a sexual harassment complaint, and I went in their lunchroom to get some water or something, and I see on their refrigerator, on their magnets, are all these really racy comic strips, dirty comics on their refrigerator. And so there I am, I'm their lawyer, they're paying me a lot of money, and I'm pulling the stuff off of their refrigerator. I then went and talked to the person who is the head of leadership in this company, and I'm talking to him, and as we're talking, I see that his screensaver is, you guessed it, a sexually inappropriate image that's flashing across his screen every few seconds as we're having this conversation. Yeah. Think, be careful, keep your eyes out, train your managers so that they understand what to be looking for and they understand how important this is. So, harassment generally can be slurs or negative stereotypes. I cannot read this small. It can be insulting jokes about particular racial groups or protected categories of people, insulting or offensive emails, insulting or offensive posters, screensavers, as I just mentioned, derogatory comments or taunts about someone's race or religion or other characteristics, intrusive questions about someone's personal life, for example, obviously touching that is uncomfortable, intimidating, or offensive, gesturing that is offensive, intimidating, or insulting. Now, sexual harassment is a particular kind of unlawful harassment. There are two kinds of sexual harassment. One is quid pro quo, which in Latin is this for that, and the other is the one that we see more frequently and that you're more familiar with most likely, which is a hostile work environment sexual harassment. Now, just quickly, quid pro quo sexual harassment, unwelcome sexual advances or requests for sexual favors when submission to the conduct is made either an explicit or implicit condition of employment, or submission to or rejection of the conduct is used as a basis for an employment decision affecting the harassed employee. go on a date with me or you're not going to get this promotion. Let me put my hand on your knee and you can be my assistant and I'll give you a big raise. Hostile work environment. Again, we see this a lot more commonly. This is verbal, visual, or physical conduct of a sexual nature when the conduct interferes with any employee's work performance or creates an intimidating, insulting, or offensive environment in the workplace for that employee. So what are the questions that we ask to consider whether hostile work environment, sexual harassment exists? We ask, is the conduct sexual in nature? Is the conduct unwelcome? Is the conduct severe or pervasive? Let's talk about welcome versus unwelcome. What does that mean? Well, the person complaining must find the behavior unwelcome, right? It's not about whether somebody else thinks the conduct would be unwelcome to them. It's about whether that person considers it unwelcome in the sense that he or she did not invite it, did not solicit it, did not participate equally in the behavior. Welcome versus unwelcome. It's a matter of perspective. You all have seen this image before. I'm sure if you look at it one way, it's two faces facing each other. If you look at it another way, it's a vase or a goblet. The question of whether certain conduct is welcome or unwelcome is based on the perspective of the complaining party. Be aware. Again, zero tolerance is our catchphrase. Employee misconduct need not rise to the level of unlawful harassment before disciplinary action is appropriate. Be on the lookout. If you or your managers or supervisors perceive anything that appears to be inappropriate, that is something that might be sexual in nature or perceived as sexual in nature, address it. Managers should be alert to conduct that exceeds the bounds of civil, respectful workplace behavior. Now, I do a lot of workplace trainings, and oftentimes I get a lot of discussion going, and it can be a lot of fun. One of the things I hear a lot from employees is, there's no fun in the workplace anymore, right? You can't say the slightest thing. You can't look at somebody the wrong way. You can't just, give somebody a friendly tap on the shoulder without being afraid that they're going to allege that you're a sexual harasser. And I understand that this is difficult, but what I say to people is, this is the workplace norm. The workplace norm today is different from how it was years ago. My dad called me a few years ago and said that he was very proud of himself because he had given his secretary a Victoria's Secret gift card for her birthday. And he had written in the card, I look forward to going with you when you try on stuff at Victoria's Secret. My dad passed away recently. He was already in his late 70s when he told me this story. You can imagine how I reacted, his employment lawyer daughter. But my point being that times have changed, and what was appropriate on Mad Men doesn't fly. And so we all have to be very careful. And as I say to the folks in the workplace trainings when they have these complaints, what's okay for you to say to your buddies when your feet are on the coffee table watching a football game is totally different from what's okay to say to your workplace buddies in the workplace. So be careful. Train your managers. Have workplace trainings. Make sure that everyone is on the alert and that issues are addressed, nipped in the bud, before somebody complains about being uncomfortable. Counseling is appropriate. When I say counseling, I mean preliminary discipline, having a conversation with an employee, even if the inappropriate conduct is perceived to be minor or an isolated one-time incident. Isn't it better to address that early on, again, nip it in the bud, rather than have something fester or develop into an uncomfortable situation that's going to cause problems, lost productivity, potential loss of an employee, and potential liability, and it's going to cost you a lot of time and effort to deal with it. All inappropriate conduct that might be construed as harassing or sexual in nature should be discussed and addressed. Open conversation and communication is the key. Some common misconceptions. I only meant to be funny. I wasn't harassing anyone. We see this all the time in our sexual harassment cases. Conduct that has the effect, again, it's in the eye of the beholder, the effect of creating a hostile work environment is prohibited. And what is hilarious to one person can be offensive to another. We all know that. Romantic relationships between two employees are harmless. It happens all the time. It does happen all the time. But employers have to think about whether they want to have a policy relating to relationships. For example, relationships between a supervisor and a subordinate. Should that be a situation where they have to report, they have to disclose, because you don't want romantic relationships in that power dynamic? And maybe somebody needs to be transferred, or maybe this needs to be addressed in some way. Think about what your policy should be, because others may be offended or perceive favoritism. And if the couple breaks up, we often see alleged sexual harassment arise. Other common misconceptions. It's not sexual harassment. It is if the conduct is between two people of the same gender. That's absolutely not true. Same-sex harassment is unlawful, according to the Supreme Court. Another misconception, very important. Most of you in your businesses have vendors. Even the mail carrier coming on your premises, you're responsible for third-party conduct in your workplace. Nothing can be done if the harassment is by a client, customer, vendor, or other employee. Wrong. Harassment by non-employees is likewise prohibited with respect to your workforce, your employees. They're your responsibility. Your managers and supervisors need to know how to handle complaints. And when I say a complaint, I don't necessarily mean somebody saying, I want to lodge a formal complaint, or giving you something in writing. I'm talking about even an offhand remark regarding some kind of concern. How do your managers and supervisors deal with that? They need to be trained to deal with that. The basics are, of course, you want your managers and supervisors to be respectful and listen. If someone comes to you, if you perceive a problem, be respectful, listen, take notes. Very important. And this is where this gets tricky and why training is important. On the one hand, you all have good people skills. You're listening, you're nodding, you're being empathetic. But at the same time, you don't want to do anything that's going to throw your company or your supervisor or manager under the bus, right? So you have to be careful not to in any way make an inadvertent admission. You don't want to characterize the behavior as inappropriate. You don't want to characterize the behavior as constituting harassment in this conversation. You can repeat back to the employee what happened. You can certainly elicit more information. You can let them know that you are listening and that you care about them. But be very careful not to say, gee, that sure is inappropriate, or yeah, I can understand how you feel harassed. We want to be careful as employers to protect ourselves against liability. And so it's tough. It's tough. It's not easy. Tell the employee that you must discuss the situation with HR or legal counsel. Your managers and supervisors need to understand this. Once a manager or supervisor is on notice of the potential existence of sexual harassment, they have an affirmative duty to report that up. They have an affirmative duty to make sure that that situation is addressed properly. Now, interestingly, this comes up all the time. You want to assure your employees that confidentiality will be respected to the fullest extent possible. Now, in the Me Too movement, we're seeing the press. One of the things that often is objected to now is that in settlements, there often is a non-disclosure or confidentiality provision. And people feel that these are gag orders and that people shouldn't be paid in exchange for silence. And I understand that. But the reality, in my experience, is that when people come to you with complaints of sexual harassment, usually they are looking for confidentiality. They're asking you for confidentiality because they're concerned about retaliation, they're concerned about their reputation. They don't necessarily want to get somebody else in trouble. They just want the situation addressed and they want to be comfortable in their work environment. So what you have to tell them is, we will respect your confidentiality to the fullest extent possible, because you can't completely keep it under wraps, right? You've got that affirmative duty to report it up and investigate it, address it, remedy it. So you can assure the employee who's concerned about their confidentiality, who's concerned about their privacy, that you'll respect that to the fullest extent possible. The next step is an investigation. Obviously, you want to work with your HR folks, with your legal counsel, to make sure that there is a prompt and impartial investigation of the situation. There needs to be a fair amount of effort put into who will do the investigating. It needs to be a neutral fact finder. and who will be spoken with as part of the investigation. And then it is your responsibility as an employer, based on the results of that investigation, to address and to remedy the situation, which can involve corrective action. It can be something creative. You might be just moving people's desks. You might be terminating somebody, depending on the severity of the circumstances. As I said at the beginning, you have to have your harassment policy in place. It has to be updated. Make sure that it includes an explanation of exactly what constitutes prohibited conduct. Make sure it talks about your zero tolerance policy. Make sure a complaint procedure is in place that provides alternative avenues for reporting. Remember at the beginning I said at least one man and one woman should be designated and trained. You have to assure people in your policy that they will be protected against retaliation if they bring a complaint or support a complaint or provide information that supports a complaint. There was a case not long ago in Massachusetts where someone was interviewed as part of an investigation, and she spoke up and said the truth, which was that she had observed some inappropriate conduct by the person who was being accused of the harassment. She was promptly terminated. Retaliation. Obviously, you're not going to do that, but retaliation can be subtle, so we want to be careful to protect people who have made a complaint or participated in the investigation or supported a complainant. Again, prompt, thorough, impartial investigation is required. This is something that people need to be trained on. You should be talking to your legal counsel about. And then corrective action when warranted. Again, that can run the gamut depending on the seriousness of the situation and the circumstances, the people involved. And of course, counseling or training when warranted. Oftentimes, counseling, discipline, training, making sure people understand what the expectations are, can be very helpful and can help you achieve that zero tolerance workplace.